welcome to the debate. I'm your host, Sana Maqbool, with you at PTV WORLD. In today's show, we will be taking a look at two important stories. The first is with reference to what has happened in the UN and regarding, of course, the Security Council's reforms. Another win for Pakistan and other like-minded countries, including Italy and Argentina, that have successfully made sure that the expansion of the UN Security Council, which has been propagated in the past by the G4 countries, India, Brazil, Germany and Japan, has been rolled over to the next General Assembly session, and that it hasn't taken place so far. This has been happening for a while now. It has been many years since the G4 countries have been trying for these reforms, for the expansion of the SCN to gain more seats. But of course, there are other countries, including Pakistan, part of the countries uniting for consensus, that have been talking about a different approach about the reforms of the Security Council, saying instead that there should be more members as non-permanent members of the Security Council who should be there for a longer duration, and the possibility of getting re-elected as well. We're going to take a look at this particular decision and how it's going to impact the UN, its Security Council, and what it means for countries like Pakistan. We're also going to be taking a look in our second segment of the show today regarding, of course, what has happened in terms of the Supreme Court's detailed verdict. A short order was given earlier when we looked at the no confidence motion that was stated earlier in March against the former Prime Minister and the PTI leadership, including the former Prime Minister. In the aftermath of that, claimed that there is a conspiracy going on, that there is a regime change that has happened and an important government has been installed. The Supreme Court's detailed verdict exposes the lies and propaganda by the PTI, its leadership and the former Prime Minister as well. And in the detailed judgment, the Supreme Court has outlined that the dissolution of the National Assembly was unconstitutional and that the Deputy Speaker in the National Assembly acted with malified intent. We're going to be taking a look at this entire judgment and trying to understand what it means and how it talks about the different aspects of the narrative that the PTI leadership still continues to claim and follow. This is going to be important, of course, in terms of the by-elections as well that are just around the corner. So that is going to be our second segment of the show today. As usual, in the studios with me for both these segments are Farrukh Pitafi and Raja Faisal. And for our first segment regarding the UN General Assembly and the Security Council's reforms, we've been joined by a very special guest. We've been joined by the permanent representative of Pakistan to the United Nations, Ambassador Munir Akram. Thank you very much, Mr. Munir Akram, for joining us and being a part of the debate.
Thank you, Pat.
I'll start with you, Mr. Munir Akram. When we look at the situation, of course, in terms of the reforms of the Security Council, this has been something that has been talked about for a long time now, and the G4 countries, of course, have been pushing for an expansion of the permanent seats. This decision has been rolled over to the next General Assembly discussion and session. But when we talk about countries like Pakistan and others who have been taking a different stance to this reform approach, how do you see the particular way that the Security Council needs to be reformed for perhaps establishing a more effective way of the Security Council? Because, of course, the UFC is proposing a completely different approach, but also is saying that it should be reformed.
Yes, of course. The Security Council needs to be expanded first and foremost because there are only 15 members. The membership of the United Nations itself has expanded to 193 states, and they need to be all equitably represented. So the solution that has been proposed by the Uniting for Consensus group led by Pakistan and Italy is that we expand only the non-permanent members who should be elected by the General Assembly periodically, in order to establish their accountability to the entire membership, which is the intention of the UN Charter, that Security Council members act on behalf of the entire membership of the United Nations. There are some countries, as you know, the Group of Four, who have insisted that they deserve to be elected as new permanent members of the Security Council. And we believe that this is against the principle of sovereign equality. It will erode equitable geographical distribution among various states, and therefore our solution is the most equitable, most reasonable and rational solution to reform of the Security Council. They have used pressure tactics, they've used their influence in order to try and steamroll their point of view, but we have been able to successfully resist that. The Uniting for Consensus, together with other like-minded countries, China, Russia, and others, we are of the view that we are not prepared at this moment to accept new permanent members on the Security Council. And there is frustration on the side of the Group of Four. The Indians, in their statement day before, stated that they are unhappy with the process and that they want to have some alternate ways of addressing the issue. So it is an expression of frustration. 2 years ago, as you know, the Indian government said we will achieve our objective while we are on the Security Council as a non-permanent member. They have failed to do so, and they are quite considerably frustrated, at least as appears from their statements here day before yesterday.
Right. Ambassador Akram, since we are talking about sovereign equality, one concern that we have seen is the question about the so-called new permanent members. If they are allowed, will they get veto power or not? Because veto power recently seems to have created more problems. Secondly, if we are going to actually talk about sovereign equality, is it not more prudent to empower General Assembly rather than Security Council? Because it seems no matter what happens, Security Council still is going to be a group of unequals.
Well, to answer your second question first, the Security Council is empowered under the UN Charter as the principal organ responsible for the maintenance of international peace and security. We can't change that. So the Security Council has its responsibilities under the Charter. We can improve its functioning, we can improve representation of the Security Council, but we cannot take away the powers of the Security Council under the Charter, to which we are all committed. The General Assembly certainly has its role and must play its role as an oversight body, as the body to which the Security Council reports and on whose behalf the Security Council acts. So we should abide by the Charter, but reform the Security Council. And obviously, creating new permanent members, we are opposed, whether they have the veto or not. We are opposed to new permanent members because that is an unequal way of reforming the Security Council, and the principle of sovereign equality does not allow that we should agree now to creating new permanent members. We were not party to the UN when the Charter was signed, and therefore 5 permanent members were created. But we cannot abide by accepting a lesser position by giving a permanent membership to additional countries while we are sitting in the United Nations.
Right.
Then, Ambassador, why do we refer to the G4 as reformers or people who want reforms? All they want is more power for themselves, addition of more power centers in the UNSC.
And also regarding the non-permanent members in the Security Council, you're talking about how there needs to be equality in terms of the representation. If they won't have the powers of a permanent members or the veto, how will that change the way the Security Council will work, and how will that add any value?
That's a good question. So here's how it's going to work. The Security Council has 15 members. We want to add at least 10 or 11 members. So then the Security Council will have 5 permanent members and 21 non-permanent members. When you calculate what is the majority required for the adoption of the decisions, that majority will go up to 16 favorable votes, and most of those votes will be from developing countries and from the non-permanent members of the Council. So the power of the non-permanent members will exponentially increase with the larger membership that they will have in the Security Council. So it will not be easy for anybody to get a resolution through without the concurrence of the non-permanent members, and the majority of whom will be developing countries. That's the way to empower the non-permanent members. We can't take away the veto of the existing 5, but we can create a countervailing power for the non-permanent members by increasing their number on the Security Council.
Yeah,
Okay.
Ambassador Akram, obviously, when we talk about sovereign equality and the representation throughout the world in the Security Council, obviously the 5 permanent members, none of them hails from the Muslim world. And when we talk about Muslim world, population of the Muslim world is almost 1/5 of the world, and there are many countries of the Muslim world. OIC is a platform they have, and none of the members of the OIC is a permanent member, either the permanent member or non-permanent member of the Security Council. Will UFC ensure that in coming future there will be representation from the Muslim world as well?
And by the way, why not actually plead the case for Pakistan rather than actually only pleading for the the case for the Muslim Ummah?
Yeah.
Pakistan, Paul Kennedy actually called India and Pakistan pivotal states. So Pakistan is very important too.
Yes, Pakistan is of course important, and that is why we are saying that we cannot accept India as a permanent member, because that leaves us out of the equation, and we are equally qualified to serve on the Security Council. But the point is that we don't want to ask for new permanent members, because there will only be 5, 4, 5, 6 new permanent members, and that will go to somebody else because they are larger countries. And they are staking a claim. And this is contrary to the principle of sovereign equality. So we are going to try and expand the non-permanent membership. We will the non-permanent membership from Asia, for example, would expand from 3 to 5 or 6, and there will be double number of seats, and therefore there will be greater opportunity for countries like Pakistan to be represented on the Security Council much more often. And naturally, a large part of Asia Pacific are Muslim countries. A large part of Africa is also Muslim countries. And if there are more seats for Africa, more seats for Asia, we will have a larger opportunity for the representation of Muslim countries and a larger opportunity for representation of Pakistan more frequently on the Security Council.
Right. Ambassador, since we are talking about postponement of this decision, don't you think that India has been at it for quite some time and they have this habit of persistence, and it can actually crop up again and pose more difficulties in coming days? Do we have any permanent solution to this? Because India keeps on lobbying and it never stops.
Well, India keeps on lobbying, but so do we. Our group the Uniting for Consensus group has proved to be more effective because we have thwarted the combined events of India, Germany, Japan, Brazil together. And we have prevented those efforts for years now. And what we are saying, and what I said in my statement the other day, is that reform has not happened because of the inflexibility of these four countries who want individual permanent membership for themselves. If they were more flexible, if they were thinking more of the United Nations as a whole rather than their own national ambitions, in particular India, I think we could have a compromise. We could work out a solution. But as long as they adopt this position that they want individual permanent membership for themselves, while not accommodating the concerns of other countries, we will need to prevent them from achieving their objectives. And we have indicated and proven that we are quite capable of doing so, and we will continue to do so unless they relent and become more flexible and accept the fact that they should be treated on the basis of sovereign equality with other members of the United Nations.
Right. Regarding the lobbying efforts, it reminds me of one article written by Richard Haas, who is chairman of CFR, right? And he wrote that if the UNSC cannot be reformed, there should be a parallel body, an important body which actually above UN, which includes Japan, Germany or Europe for that matter, India and America, and that should actually be setting the agenda. Don't you think that if the UNSC cannot find a solution, some kind of resolution by permanently removing, the negative elements, complaints, till that time, perhaps such efforts to undermine the UN will also continue?
And since you have to leave, Ambassador Akram, so I'm just going to put in the last question forward as well with regards to the text-based negotiations and what exactly may be the issue with that, whether or not that's a feasible option, and how come the Assembly's president forwarded the draft decision to the members?
Let me say firstly on the text-based negotiation is a demand from the G4, from the Group of Four and their supporters. They want to begin looking at a text of what are the different options and negotiating. And what we are saying is that until you agree on the broad principles of what the reform is going to be like, which is agree on the size, agree on which regions will get how many seats, agree on the categories and where we do not accept permanent membership, and therefore there has to be some form of non-permanent membership. Unless we agree on these major principles of the reform, what is the point of going to a text and beginning to bicker over a text? Because that will only solidify the positions, and there will be a deadlock. Whereas the present process, which is more informal, at least allows us to discuss various options and see if there's flexibility which we can exploit to promote a compromise. So that's the position of the UFC, and that is the position which has prevailed in the General Assembly so far, in accordance with the decision to roll over the IGN informal negotiating process. Now, as far as creating other bodies, those have been tried. I mean, you have the G20, which was created for economic reasons. Now they're raising political issues there as such. But these bodies will never have the same legitimacy of a commitment by the entire international community. The UN Charter is what has been signed as a legal treaty by 193 member states, and therefore it has the widest universal commitment from all states, and that legitimacy will never be acquired by a partial solution, which may be attempted by some powers.
Right. Thank you very much, Ambassador Munir Akram, the permanent representative of Pakistan to the United Nations, for joining us and being a part of the debate. Of course, there is much that remains to be done with regards to the UN and the Security Council and the reforms, but Pakistan's stance is clear on the matter, and we only hope that by reforming we develop a more efficient and a more productive system whereby we can actually help the people and the countries that are in need of help, and what the United Nations, of course, seeks to achieve in terms of its various purposes. It does so with more rigor and more passion and an easier and smoother way as well. We're now going to be moving on to our second segment, which is of course on the Supreme Court's verdict regarding the no confidence motion that happened against the former Prime Minister Imran Khan. The PTI leadership in the aftermath of that, of course, challenged a lot of things that have been happening in the country, and the political scenario has been defined by that narrative as well. We have seen the short order come earlier, and now the detailed decision points to the fact that what happened in the National Assembly and its dissolution was unconstitutional, and that the Deputy Speaker acted with malified intent. Farrukh, when we look at this detailed verdict, this is something, of course, that we know from the short order as well. Yeah. But since then, it's not like the stance of PTI has changed, or that they have backed off from what they had claimed earlier as well. In fact, they probably have strengthened that even more and also formed that as part of their campaigns as well. But when we look at the Supreme Court's verdict, do you think that it in any way damages or finds loopholes and breaks through this whole argument and case that the PTI has constructed?
Right. I think it does all of that. But first of all, it is not the Honorable Supreme Court's job to take wind out of any party's sails. So it didn't seek to do that. Of course, PTI can go on saying whatever it wants to its constituents. That doesn't mean it is going to change anything in the law or the loopholes that we have seen. We have seen loopholes. We have seen something that was honestly unthought of in the past, when the former deputy speaker actually tried to dismiss a session or a move to remove the prime minister by citing a document that he didn't even show to the constituents of the assembly. And that is not all. Then the former prime minister actually attempted to dismiss the assembly as well. So that is a humongously problematic issue. And that's why Supreme Court of Pakistan has taken a legalistic approach and deconstructed the whole case there, right? First of all, Supreme Court is telling you that that so-called cipher was not even shown to the honorable judges. They kept on saying, the deputy speaker said that we have sent a copy to the honorable chief justice, we have sent it to the president, this, that, and the other person. Didn't happen. There were only portions of it that were shown, or the honorable court was informed about it. And then, of course, this loophole of citing, assemblies or parliamentary immunity to such an act where you are actually sabotaging a democratic move. That again has been pointed out by the Honorable Court that did not enjoy the immunity under Article 69(1). So that is cleared, and at this moment what we know is that the previous government tried to actually did not play by the rules, and it tried to use national security, or at least illusion of national security, to get away with whatever they wanted to. And that's why they are going to face consequences.
Right. Let me also welcome in the debate Sardar Balksher Khosa and Mr. Salman Akram Raja, both senior lawyers. Thank you very much for joining us on the debate. Mr. Salman Akram has joined us on telephone line. Mr. Salman, when we look at the Supreme Court's verdict, of course, this particular order had come out earlier in the past as well. And when it did, there was a lot of debate regarding the fact that whether or not the courts had a stance that was fair. And now that we look at the detailed verdict as well, it has, of course, talked about how the decisions and the actions of the National Assembly were unconstitutional, and that the Deputy Speaker acted with malified intent. Do you think that this detailed verdict puts all those questions that had been raised earlier regarding the Supreme Court's role, or the court's role in general in Pakistan, all to bed?
Yes, I think the judgment answers, many questions. It's a technically rigorous judgment. This is not a political judgment. No. And frankly, there is not much that they have done by way of interpreting things, as is often the case in judgments when meanings are read into words which, can surprise us. This is a very narrow judgment, narrowly argued, and remains very close to the language of the Constitution. Now, what the court has essentially said is that the Deputy Speaker, Mr. Qasim Suri, on the 3rd of April had no jurisdiction, no authority to prevent a vote on the resolution of no confidence. The resolution was before the House under Article 95. It was a right of the opposition to vote on that resolution, and indeed of all members of Parliament of the National Assembly to vote on that resolution. And Mr. Qasim Suri, by arbitrarily terminating the resolution on a so-called point of order raised by the law minister, acted in excess of the authority vested in him by the law. And since his action was a nullity, the subsequent advice by the Prime Minister to the President to dissolve the National Assembly was also a nullity, because as soon as Mr. Qasim Suri's ruling goes away, the resolution for no confidence is deemed to have been pending, and the Prime Minister against whom such a resolution is pending cannot advise dissolution of the National Assembly. And therefore, the action taken by the President on the void advice given by the Prime Minister was also void and therefore was reversed, with the consequence that the National Assembly came back and the National Assembly was directed to proceed with the vote on the confidence resolution, which happened, and we know what happened thereafter. So that is really, in a nutshell, what this judgment is about. It is about Mr. Qasim Suri's action of terminating the vote on the resolution of no confidence. I look at it, in this kind of narrow technical context, and I think that is the correct context in which to look at this judgment.
Technical aspects are important, and I think that it is true that the Honorable Court has looked at the technical questions, but there are political questions that follow from this. For example, the Federal Interior Minister just an hour ago actually called for the President of Pakistan to step down. Do you think that in any scenario that is a possibility, or does that consequence include him as well?
Well, that can be a political demand, and any politician is entitled to make a political demand. But the Constitution does not require him to step down. The only way to remove the President is through an impeachment, and the process for that is given in the Constitution itself. Now, if you look at what the President did, he simply complied with advice given to him by the Prime Minister. And in doing so, he did what the Constitution expects him to do. And the Prime Minister did what he did based on Qasim Suri's illegal ruling. So we go back to Qasim Suri's illegal ruling, and the question that can be raised is whether the Prime Minister was complicit, whether this was, a scheme hatched to obstruct the no-confidence vote. And so that is something one can, surmise about, and one can have views about that. But the President, on his own, did something that the Constitution, in essence requires him to do. One could accuse him of being complicit, of being part of the scheme, but the constitutional position is that once a president gets advice from the Prime Minister, he has to obey that advice. He can delay it, he can send it back for reconsideration. But his acting on it is not as such a constitutional wrong.
Exactly. Yeah, Raja Saab, talking about the political demands, we are hearing on news once again from the government side as well that after this, jurisdiction, of course, few of the previous government members, of course, the Law Minister and Deputy Speaker and Prime Minister as well, they can be tried under the Article 6. Is it possible, sir?
Again, that is a very contentious position to take. Now, my own opinion on this is that Justice Mian Khail has, asked a question. He has said that, look, this was something that made a mockery of the constitutional process. Will Parliament do something about this, to stop such a thing happening in the future? So he's actually addressed Parliament. Now, the Article 6 prosecution under the High Treason Act is something that vests in the federal government. The federal government has to decide whether to initiate such prosecution or not. Now, in my view, in my humble opinion, this is not the correct moment to do that. What has happened here is one wrong ruling by the Deputy Speaker. Everything else has followed that wrong ruling. The court has corrected that ruling. The court announced no confidence resolution to go ahead. It was voted on. So we can't really say that the Constitution stood suspended or abrogated to the language of Article 6. An illegal act took place. That illegal act was relatively quickly remedied by the court, and the constitutional process was allowed to proceed. Should we be seeking treason charges against anyone based on this? Now, remember, treason carries the death sentence with it. We're already, going through a very poisonous political episode or a period of great strife in our politics. So it's for the government to decide whether it wishes to push this and arrest people and charge them with an offense that carries the death sentence. Is that the way forward for our politics? That's
right.
for the government to decide. As far as the legality of it is concerned, the government has the discretion to go ahead with it and level charges. I personally feel this is not an Article 6 case.
All right. Khosa Saab, if not the Article 6, but when we talk about the illegal action that has taken place, what sort of legal consequences should be there, or how should the Parliament be able to proceed further regarding this? Should it be just, should we just let it be, considering the fact that what earlier was being talked about, how the scenario played out and how the Constitution did eventually follow its own path? But should this action in itself, if it's declared illegal, not have any legal consequences?
And should this this judgment be enough as a precedent, or should the Parliament close the loophole by making laws?
Thank you very much. And after Salman Raja being my senior, I think so. I don't need to spell out anything, but I'll add to Raja Saab. He's a very legendary senior counsel to me and very respectable to me. Well, exactly, the Supreme Court judgment is a judgment which needs to have a little elaborations, which is lacking in this judgment. But one thing is very clear regarding his Lordship Mandukhan Sahab, the Honorable Judge of the Supreme Court, has very clearly said so. He has used the word however. However means that this is not high treason. You see, I'll just quote one thing, that every day there are being fundamental rights are being infringed, and there are so.
Right. Unfortunately, we are unable to hear Khosa Saab, but we'll try and establish our contact once again. Salman sir, if you could take the same question.
Sorry, could
what
you
other,
repeat
if not
the
Article
question?
6, and what other options do we have? Yes.
Can you repeat the question, please?
So, with regards to Article 6 as a legal consequence, of course, you've given us your viewpoint regarding that. But besides that, what other legal options can the government or the Parliament exercise with regards to this illegal action?
And by the way, since we are talking about loopholes that were exploited by a political party, is this precedent enough, or should the Parliament also make laws to close these loopholes?
Well, Parliament could clarify this further. Parliament could, make laws or amend the rules of the National Assembly to say that no speaker will ever have the authority to prevent a vote on a no confidence resolution. The things that this judgment has brought out, the Honorable Chief Justice's judgment, there are a lot of things there regarding the nature of the power that the Speaker or the Deputy Speaker exercises. So that judgment could be legislated on and made a part of a law, or even made a part of the rules of the National Assembly. So that possibility is there. And I think that is what Justice Mia Khair in his individual judgment, which is not the judgment of the court, is alluding to. And I think doing that would be a constructive thing to do. But launching an Article 6 prosecution is a very different reaction to what has happened. So Parliament legislating and giving effect to what the judgment has said, the majority judgment has said, I think would be a very welcome thing to do.
Right. Raja Sahab, earlier you were talking, when you were talking about invoking Article 6, you said that at this moment the situation in the country is already very polarized, and I can see how that is a reality. But with due respect, regarding the consequences, without consequences, we can be sure that similar kind of acts will be taken in the future as well. So is it not important to set the record straight and to actually make people face consequences? Because in the end, it becomes another law of necessity, because at this moment necessity dictates that circumstances are such that you don't take any action at all.
Right, and perhaps the consequences of these illegal actions have ripples that are far beyond right now what we're experiencing.
No, you see, illegal actions take place all the time.
Right.
In the past, presidents have dissolved the National Assembly, and the court in 1993 restored Mia Nawaz Sharif's government and said President Ghulam Ishaq Khan had acted illegally. Nobody said we are going to move an Article 6 prosecution against him. So one illegal action is not treason. Sometimes people in good faith, can read the law improperly, come to a wrong conclusion about what the Constitution requires, and take a decision or make an action which is found by the courts to be improper and illegal or unconstitutional. This happens all the time. Our law books are full of judgments in which actions have been declared to be unconstitutional. An unconstitutional action per se does not amount to subversion or abrogation of the Constitution. Read Article 6. Those are the words used in Article 6. So is this subversion of the Constitution? One could argue maybe yes, maybe not. I would argue it was a grave mistake, maybe a mala fide mistake, a deliberate mistake. They tried to stall the constitutional process, and for that the courts intervened and allowed the process to go through. You can legislate and make this some kind of a criminal offense short of treason. Treason is a very, very big thing. So the offense that this was, if at all it is an offense, has not yet been legislated upon. And that is what Justice Mia Khail is saying, that there should be maybe something added to the disqualification, if you like, clause in the Constitution, Article 63. So some kinds of constitutional mistakes can lead to disqualification or to the unseating of a member or an office bearer. But Article 6 is the ultimate, if you like, offense.
All right. And I want to talk about that a bit further regarding treason. As you were mentioning, of course, it's a very, very big thing. But Khosa Saab, when we look at what happened earlier as well, there were a lot of accusations coming in from the previous leadership as well that the then opposition parties are accused of treason, or that perhaps the way that they're acting in, considering the so-called regime change and the conspiracy that was being claimed, does constitute as treason. Whether or not that legally, of course, constitutes Article 6 or treason or not is one thing, but the repercussions of the way that it's viewed, of course, also exist, of how people are going to be viewing these people, whether or not they're guilty of treason. Is there any legal consequence or some sort of legal matter that takes care of the fact that no such accusation can be made without evidence, or if it is, then there is a consequence of that as well?
And sir, we are talking right now about the action of April 3, right?
Yes.
But the crisis continued till April 9. And at that time, there were calls for civil war and umpteen other things as well. Should we merely be focusing on what happened on April 3, or should we focus on, the whole crisis holistically?
Yeah, of course one can do that. And then what happened in Punjab with the Governor Sarfaraz Cheema, so there was clearly an attempt to disrupt the constitutional process. So what I'm saying is that we need to decide whether you want to prosecute all these people under Article 6 or not, or whether you want for the future to legislate and put in place some law which would result in these people being removed from office or being disqualified from holding office in the future. I think that would be the appropriate way forward. Article 6 is there. You can try your chances with that. To my mind, it is the ultimate extreme move that should come into play when somebody has imposed a martial law, somebody has incarcerated 60 judges for 100 days. That kind of a situation is an assault on the constitutional process, which completely balances the constitutional process. So here what
would be great if the
of illegalities committed by various bearers all I agree be punished, and this should be turned into some kind of an offence that results in
it would be great if the Honourable Court could interpret Article 6.
I've given you my opinion. It's to the government to decide what it wants to do and proceed.
Would be great if the Honourable Courts or then the Parliament could actually define the contours of Article 6 by limiting the number of offences that can be included in that, as you have pointed out. But let us go to Khosa Saab, who has been waiting for his turn.
Khosa Saab, coming towards you, if we talk about the loopholes, was it a matter of doing illegal through the legal means? The way it was portrayed and the way it was done that day, it seemed as if everything is part of the legal process. But now, obviously, after the jurisdiction from the courts, we are aware that everything was illegal, but of course it was portrayed as the legal. Should it be considered that the loopholes, they are in the Constitution, and of course them loopholes, they are constantly being used and in future these loopholes need to be controlled or contained?
You see, it has been very much clear about if some state machinery is going to do something wrong or take the powers into their own hand or makes an illegal order, then you go to Article 199 of the Constitution, Islamic Republic of Pakistan, where you invoke the jurisdiction of the Honorable Lahore High Court or any High Court of the province. And likewise, if something is of the national importance, a dispute between the provinces, then definitely the matter is related to the Honorable Supreme Court of Pakistan and the matter will be taken up by the Supreme Court of Pakistan. Well, you are absolutely correct. If the parliament is not going to define Article 6, then definitely the judicial orders, the Supreme Court has to interpret the law. But in this judgment, in this case, in the judgment of the paragraph which I have already suggested of His Lordship Mr. Justice Madhakhil, the Honorable Judge of the Supreme Court of Pakistan, he has said so the word however means they have referred the matter to the parliament, that the parliament has to describe Article 6, because Article 6 is always there where the constitution is being suspended, where the fundamental rights are being suspended, where there is some act of the parliament or the president or any other authority above the constitution. So that act is high treason. So it needs to be elaborated by the parliament, has been referred by the Honorable Supreme Court of Pakistan in the instant judgment. And on the other hand, yes, when the judgment is there, the judicial order is there, that the deputy speaker has done something above the law, above the constitution. Yes, there has to be a procedure. There has to be something which the parliament has to do, that such member has to be removed as the member of National Assembly because he has done something unconstitutional, above the constitutional mandate which he has taken from the public, from the people of Islamic
Right.
Republic
I
of
understand,
Pakistan.
Khosa Sahab, but I have another question for you. When we talk about the events, of course, that have happened since then and how the political scenario has evolved and changed, there have, of course, been many institutions, including the parliament and others, that have been under fire. Would you think that when we talk about the Supreme Court, its verdict and the way that the courts are viewed by the larger public within Pakistan, has the court also taken a hit in terms of the way it's viewed and whether or not it's considered impartial?
And should the honorable courts be bothered about that kind of hit at all?
I must congratulate the Honorable Chief Justice Pakistan and the Honorable Judges. Yes, they have admitted previously the courts are being giving shelter in the regime of General Ziaul Haq, in the regime of General Pervez Musharraf. Their acts have been condemned in this judgment. And they have said very loud and clear that we are not going to give any shelter to unconstitutional act, to the necessity of needs and deeds. They have said so that we are not going to go with the doctrine of necessity. And they have condemned their judiciary as well. They have condemned and they have admitted their fault in front of the people of Pakistan. So I think so that's a great, huge effort and admission.
No, that is true. Khosa Sahab,
Pakistan.
that is a very valid point that you have raised. But Khosa Sahab, with due respect, these honorable courts are not elected bodies. They have their own purpose and they are there, they will exist, right? Why should anybody be bothered if somebody is actually trying to portray them negatively? The honorable courts should be taking notice if they have to, but image clearly shouldn't be an issue with any court. When we used to do polling, there used to be good polling and bad polling, and the context was that bad polling is when you are actually telling an institution whose job it is to interpret the constitution independent of public sentiment to actually look at their approval ratings, right? At this moment, should there be any talk of that at all? Because I understand that in itself, slandering the honorable courts is a crime in itself, right? But this whole idea of this judgment leading to this kind of image or imputation, should that be there, especially when Parliament or the executive failed to do their job of enforcing the law properly, and then the honorable courts actually have to take care of the matter?
Absolutely. It is very loud and clear written in the 1980 rules of the Supreme Court of Pakistan when the suo motu is being taken on the issues where the parliament or the executive authorities, they fail to interpret the constitution. Then the Supreme Court shall, the word is shall, interpret the law. But in the instant judgment, you have seen that Supreme Court has said so. There are only two occasions when the assemblies are dissolved. Number one, on the completion of its 5 years. Yes. And number two, the Prime Minister has the authority to recommend the President under
Right, but Khosa Sahab, the question is whether or not the Supreme Court or the courts in general should be concerned about their image.
The Supreme Court and this is an unfortunate state of affair, which I admit on the part of being part of that judiciary, because as being officer of the law, we are part of the judiciary. We are hit by the media, we are hit by the people of Pakistan, we are hit by their thoughts, we watch the television, we watch their views. So I think so that is a judgment is the reflection of the views of the people of Pakistan, which should not be under consideration at all, because the constitution has to prevail. The rule of
all
law
right.
has
Thank you very much. Thank you very much, Mr. Sardar Bakhshir Khosa, for joining us and sharing your views with us. Unfortunately, that's all we have time for. And of course, the Supreme Court's verdict and its decisions and the supremacy of the Constitution is something that we can all agree on. We can only hope that this is something that is understood by the decision makers sitting in the Parliament as well. Thank you very much. That's all from the debate. We'll see you tomorrow.